Mr. Ballantyne? Here. Mrs. Christie? Here. Mr. Spees? Here. Mr. Brookter? Here. Mr. Guidry?
Here.
Mr. Chairman, we have a quorum.
Thank you, Madam Secretary. Before we get started, just to have a few public announcements. If everyone would please silence their phones and electronic devices, we would appreciate it. With regards to appeals, any aggrieved party may appeal a decision of the BOA to the district court. With regard to speakers and speaker cards, if you would like to speak in favor or in opposition to one of the applications, please fill out a card that is on the podium here. Oh, it's on this side. This side this week, and they'll get those up to me, please. With regards to public speaking, each side will have 10 minutes to speak, and there'll be a 5-minute rebuttal period. And also, if you need to get out into the lobby to speak, we can still hear your conversation in here, and it's disruptive. So if you wouldn't mind stepping outside of the building, that'd be appreciated. With that, has everyone on the board had an opportunity to review the December 1st, 2020 meeting minutes? With that, I'll entertain a motion to approve those minutes.
I make a motion to accept the minutes from our last meeting.
We have a motion and a second. All those in favor?
Hold on, we have to vote with the,
Please vote with your machines.
Where's Mr. Blake?
Mr. Blaze had to leave. Where's my vote? Can you set up the vote? Yep. Okay.
and Mr. Spees is here. Motion pass.
Thank you. Moving on to our first case, case number 2020-2135, request by applicant in an A2 suburban zoning district for an after-the-fact waiver of the required 50-foot no-cut buffer along the south side of the property where the single-family residence is located, and to replant the partially cleared no-cut buffer, southern 50-foot no-cut buffer. The property is located at 59375 Lacombe Harbor Lane, Lacombe, Louisiana, and the applicant is Ashley Ray. Staff comments, please.
Revised replanting plan have been submitted to be reviewed and considered by staff and the board. Option 1, the proposed replanting plan shows a total of 46 trees to supplement the existing remaining trees with a 50-foot wide buffer for a distance of 840 feet. The selection of trees is suitable for the area, and the plan is legible, clear, and drawn to scale. However, the proposed width of 15 feet for the buffer does not meet the intent of the ordinance to replace the required 50-foot no-cut buffer. Option 2, the proposed replanting plan shows 69 trees to supplement the existing remaining trees within a 50-foot wide buffer for a distance of 840 feet, which meets the intent of the ordinance and the objective of the regulation.
Thank you. I see the applicant's representative is here. Would you please state your name and address for the record?
Yes, sir, Chairman Guidry. My name is the microphone on? Can you hear me?
Mike.
Yes, mic is on.
Yes, sir, Chairman. My name is Trey Late. My office address is 1966 North Highway 190, Suite B, Covington 70433. I'm here as the attorney for Mr. and Mrs. Ray, both of whom are here, sir.
Thank you. Do you have any further comments?
I do. Am I entitled to time?
Yes,
today?
you have 10 minutes.
It was continued. I will not need that much.
Okay.
As you all recall, I was here before you on December the 1st.
Wait a minute, hold on.
Please, 1 second.
We're just switching it back. We're just switching it back. Yeah, pick up first, and then add the 10.
Go ahead. Proceed, please.
Thank you. As you recall, I was here before you on December the 1st. I will not rehash that meeting. I will highlight some of the statements that were made, beginning with that of Assistant Director Lambert, commenting that recreating a 50-foot buffer as it existed prior to it having been cut is neither possible nor feasible. Commissioner Brookter You commented that this board had previously asked Mr. and Mrs. Ray to come back before you to submit a replanting plan. We attempted to do that in December. We learned at that meeting from comments from Regan that the discussions that Regan had had with my client's former landscape architect, Mr. DeLauder, that she had been asked to put the replanting plan onto the two-scale tree survey showing a two-scale with the location of the house. After some procedural motions, it was moved by Commissioner Thomas to continue that, and we're back here before you today. We have submitted timely 2 replanting plans. You all should have both of those. I have graphical demonstrations of them before you today. Staff has blessed that which is styled as a 50-foot replanting plan and not blessed that which is styled as a 15-foot replanting plan. We are presenting them both to you. Mr. and Mrs. Ray are asking for your consideration for the 15-foot plan, what is styled as a 15-foot plan. If you are not inclined to grant that, then we have the 50-foot plan as an alternate. I'd like to point out some of the, while we're calling them a 15-foot plan and a 50-foot plan, if you draw your attention to what is styled as the 50-foot plan, the primary difference is, in general, 20-some-odd wax myrtles at the back of the property on the south side of the property, farthest away from, I would venture to say, any opposition that you have before you today. When we were here before you in December, we had at that time in the record a letter of no opposition, which staff has, dated November the 23rd, 2020. When we came before you in December, we represented to you truthfully that we had worked with any neighboring property owner who had an interest in dealing with us. After the December meeting, I began communicating to Attorney Tony Lamont, who's here today and had represented himself to your board as the attorney for Lacombe Harbor Property Owners Association. It was some time after Mr. Lamont and I were ever able to actually speak. Mr. Lamont and I did speak on December the 14th when we were each in court representing other clients, and the gist of it was, is there anything that we can do to appease your clients and try to come back before this board in an amicable manner and not a repeat of the December hearing? My understanding is that Mr. Lamont's client's primary interest is they want the driveway off of Lacombe Harbor Road, and that if my client was willing to not access that public road from her property, that the opposition at this hearing and the separate lawsuit that is filed against my client would go away. I have followed up with Mr. Lamont since then on December 22nd, to which I've received no response. I'm not the fastest ship in the sea, but after enough times, I can learn when somebody doesn't want to talk to me or deal with my client. I'd like to address specifically, Mr. Ballantine, you mentioned at the last hearing that you had seen a letter from Mr. Lamont to you that you were giving consideration to, and you mentioned that there were dimensions and widths of trees that were prescribed in that letter. I believe there's a reason why staff does not reference such an ordinance, is because it does not apply to a replanting request and a variance request. I have not seen that letter from Mr. Lamont because I have not received responses other than a conversation that we had in court. This board is looking at this from a discretionary manner only to address the intent of the ordinances, which is to reestablish a buffer. We've come before you once, we've come before you twice. We're here today with a new replanting plan than that which was previously described back in December as on the back of an envelope. 2 landscaping professionals, 2 plans. We're asking for your consideration. My request to you is as you look between, and I'm making air quotes, the 15-foot plan and the 50-foot plan, the only difference here primarily is some wax myrtles in the back. And my question for the board is what does that accomplish by requiring my client to put those additional 20 plants there? And my suggestion to you is nothing. And I would appreciate your consideration of what is styled as the 15-foot plan, as it does reestablish a buffer. And in the event that you're not inclined to it, then we offer you what is styled as the 50-foot buffer in addition to that. If you have any questions, I'm happy to field them at this time. I'd like to reserve some time, I presume, after opposition speaks.
We'll hear from opposition first, and then the
Thank
board will address any questions they may have. We did get 3 requests to speak. Those were all checked as against in which to speak. We did get an additional card for against that did not wish to speak. So I have Mr. Tony Lamont, we have Carl Ernst, and Isabel Moore. Mr. Lamont, I'll remind you that the opposition has 10 minutes.
Okay. Thank you for taking the time to allow us to speak on behalf of the Lacombe Harbor Landowner Association. I don't want to beat this dead horse because I think it's been beat enough. Can you hear me? I don't want to, can you all hear me? Do you mind if I take
Is the
my
mic
mask
on,
off?
sir?
Is that better?
Give me 1 second.
It's on.
Okay. It should be on, Mr. Lamont.
Can you all hear me now?
1 second.
Can you hear me now?
It's on, your mic is on, but it is a bit difficult to hear. Let's try.
Let's try this. Can you all hear me now?
Perfect, yes.
Okay.
Thank you. Sorry about that.
First of all, I want to thank everyone on the board for giving us the time to discuss this matter on behalf of the Lacombe Landowner Association. I've discussed this before this board numerous times last year, leading to an October 6th ruling by this body denying a variance to Ms. Ray. And at that time, and in the minutes of the October meeting, it was made clear that when that variance was denied, that she was to submit a plan for a 50-foot buffer in the entire perimeter of the property. What she submitted last meeting was not a replanting of the entire 50 feet. And part of that problem was, and we discovered it at that meeting, was that after she was cited for violating the no buffer zone ordinance by code enforcement, she decided to go ahead and construct her home 35 feet into the southern no-cut buffer zone. Another purposeful, knowledgeable infraction of our zoning laws. It therefore became obvious that she was not going to ask that she be required to plant trees on her house or around her, in close proximity to her home, and that therefore resulted in a request, obviously, that she's seeking now, this 15-foot buffer. She's not just looking for the 15-foot buffer on the southern side where her house is located, but the entire southern perimeter of her property, without showing any compelling reason for that. No, we're not necessarily asking you all to deprive her of her right to keep her house where it was illegally placed. But I think that there are 2 sides to this. There is a side that has to do with replanting, which she was ordered to do October the 6th, and there's a fining side when somebody purposely puts their property in a no buffer zone because it gave her a better view of Bayou Lacombe, basically, is why I think she did it. And I think that also was what prompted her to cut a bunch of the trees that she's cut and trimmed and cut and trimmed for many, many months. If this board allows her a variance, it sets a very dangerous precedent, which is one of the reasons why variances are denied. And that is that if somebody's out there purposely cutting down trees on their property, they were notified that they needed a permit, and they basically said, no, I don't, I know people and in the parish, and I don't need to do that. I'll get away with it, basically. When somebody purposely does that, and then they go and they purposely build a house on a no buffer zone and then say, well, I can't now put trees on it because I've put my house on it, it just seems to me like there's a very purposeful intent to violate our zoning ordinances, and it does set a dangerous precedent if we're going to allow individuals to do that. Now, and I don't know if you all have a copy of my letter that I submitted today, but I have a letter that I submitted today to Ms. Lambert, and I asked her to please expedite it to you all. I sent it to her about 11 o'clock today. And have you all gotten that letter?
Yeah.
Okay. Yeah, and unfortunately, we found out today what the legal opinion was that was given to the board in relating to the parish officials relating to the position on that we had taken in the last meeting on res judicata, and that basically we had requested that legal opinion because we felt that that was an important issue for you all to understand as board members, that when somebody is denied a variance, can they keep resubmitting essentially the same variance over and over again? And I'm going to just point out a few things in this letter. The ruling on October the 6th was to deny the variance and to order the replanting within 50 on the 50-foot buffer zone for the entire perimeter. The request here is to basically reduce that order, to modify it. Well, there's an appeal process that you take. If you're going to seek it, you go to the 22nd Judicial District Court, as was pointed out at the very beginning of this meeting. That did not happen. It was not timely brought. But now to circumvent those appeal rights, they have now submitted this new variance request, which essentially changes an order that you all made on October the 6th. So I don't see where there really is, I really see this as an appeal of that ruling. We argue again that should be final. And even if legally it's not, as a policy of this board, I would respectfully suggest to you that if you don't uphold your rulings, you're going to have people resubmit the same variance applications over and over again whenever they feel like it. And in this case, the variance application was prompted by the illegally placing of a house on that 50-foot southern buffer zone. So I would just point that out because I think that's a very important point to be made. Tree preservation is extremely important, preservation of our natural resources in this community and in this zoned area as well. It's a rural area. So, even if you were to give her and I would argue at most, a narrow variance so that she doesn't have to plant trees on her house itself, I would suggest to you that the fining, that she should be fined for what she's done to violate all these zoning ordinances and to just come right out and purposefully do it over and over again. I would ask if anyone has questions to please allow me to ask those.
Pardon me, we want to go through, there's 2 additional speakers if there's time allowed.
Okay.
We still have time?
Okay.
Okay, so we have Mr. Carl Ernst and Ms. Isabel Moore, whoever wants to go first.
Mr. Chairman, how much time did I get?
10 minutes total.
No, whatever was left.
Whatever's left, yes.
That was 2 minutes and 50 seconds.
Oh, there was 2 minutes left, I'm sorry.
So we still have 2 minutes and 50
All right,
seconds.
I'll be quick.
Thank you, sir. Would you state your name and address?
I'm sorry. Carl Lawrence. I live in Lacombe Harbor in Lacombe, Louisiana. Ms. Ray's attorney said that this really boils down to a few wax myrtles. I would submit to you what it boils down to is the 50-foot no buffer zone versus a 15-foot no buffer zone. 3 precedents, if you approve that, 3, all right? That it's okay to ignore the buffer zones. It's okay to clear cut a piece of property in wetlands. It's okay to build your house inside of the 50-foot buffer zone without approval, which is probably a violation of a building permit. So I submit to you, it's not about wax myrtles. It's about 50 feet versus 15 feet and holding someone accountable for 5 or 6 violations of ordinance and or federal law. Thank you.
Thank you. Ms. Moore?
My name is Isabel Moore. I reside in Lacombe, Louisiana.
Thank you.
I'm not an expert, but I do know a lot about horticulture and trees. I read the landscape map, and if you did, you will see the size of the trees that are supposed to be on the replanting map. There are 5-inch pine trees. There are 18-inch pin oaks. This Somebody lost. I even had the roots on them. And this is another pin oak that's 5 inches. Trees listed: 8-inch hollies, 6-inch gum, 6 and 12-inch pine trees. The biggest one is an 18-inch tree. You know how long these are gonna take to grow? Oh, sorry. Trees got in the way.
Thank you, Mr. Leonard.
10-inch live oak. That's the size that's proposed on that replanting map. I think it's an insult to you to think that a tree that size is gonna be not getting mowed down by a lawnmower. I know my husband cuts them down when they grow in the garden. Anyway, thank you. I'm asking again that you reconsider. Last time, she didn't tell you, she built 35 feet into the buffer. She did. Now she can only put 15 foot of replanting. It's an insult to anybody that pays taxes and follows law.
Thank you, Ms. Moore. Is there any time left?
It'll be rebuttal.
Oh, this,
Just interject
Okay.
one thing. We cannot
Set it for 5
possibly,
minutes.
I'm sorry, we cannot possibly,
wait, 1 second, Mr. Lamont. We have, this will be rebuttal.
Yeah.
We're going to go back to the applicant's representative.
are you going to allow me to do that?
Yes, we will.
Would he be allowed to speak out?
Whatever you guys want to work out there.
I would have rather gone last, but whatever you prefer.
Okay.
Hello? Touch the clip? What? Hello?
We good. Thank you.
Any chance I could have my time reset?
Yes, we're good. Yes.
No problem, Director. You have before you a group in opposition to our request for a variance who is simultaneously asking a judicial court today to grant a judgment that they have acquired ownership of Mr. and Mrs. Ray's property. What is their basis for that claim? There's a principle in the law called acquisitive prescription. It says if you got an okay title, you can get ownership in around 10 years. If you don't have any title, you can squat on it for 30 years and then be declared the owner. So what's the basis of their claim that the judge should tell Mr. and Mrs. Ray, you don't own this property anymore, it goes to Lacombe Harbor? It's because Lacombe Harbor says, well, we cut the grass and acted as the owner. Interesting. Where'd you do that? It would be in the same exact no-cut buffer that they're here asking that this board fine, penalize, and hold my clients accountable for after we have twice gone through a landscaping proposal, worked with the parish staff. Is there anyone here, well, I don't want to ask rhetorical questions. That is a duplicitous, unreasonable, hypocritical position. It is unreasonable for this board to sanction any group of homeowners to come before a court at one time and at the same time say, what we did was okay, we own their property now, but when they did it, they need to be fined and held accountable. That's enough on that. Res judicata, I'm not addressing that. I listened to the entire meeting after this time left. I understand the questions that were asked of counsel. I have not received a copy of Mr. Lamont's letter because I can't get a response. So any attempt to try to work with the neighbor on that side has been unsuccessful. As far as a policy of trees being planted, we're bringing to you a plan by a licensed landscape architect in advance, on time, with the parish's arborist. Staff approves of one of them. The Rays would like to have a view of Lacombe Harbor and have asked that the plan styled as the 15 feet be considered. If you don't, okay, we understand. We're here asking for a variance. All these comments about Mr. Ray's willful violation, we disagree with that. That's not before this board. You know, are there any questions for me?
We're going to hold questions at the rebuttal. Mr. Lamont?
No. 10.
Okay, there's no one speaking. Okay, come on up. Okay.
Thank you, sir. This will be quick because Mr. Lamont has the acquisitive possession is not trying to seize Ms. Ray's property. That's patently false. It's a question of whether there's a strip of land between the roadway and what the parish has on either side of a roadway, and you all know that. And there's a strip of land beyond that before the raised property, we believe, based on a 1973 document that Lacombe Harbor Landowner Association has from St. Tammany Parish. The question is, the court will have to decide if that's in fact correct. It is not trying to get part of our property. It's a question of ownership of a piece of property Lacombe Harbor's Landowner Association has and has maintained for 45 years.
Thank you. How much time do we have left?
4 minutes.
4 minutes. For rebuttal. We still have 4 minutes in rebuttal? Okay.
Okay, thank you for your time again. We cannot possibly go into all the details of the replanting options that have been presented, but if you will, on pages 4, 5, and 6 of my letter to this board today, I do outline some criticisms of those replanting plans. And it has to do with, particularly with regard to option 2, which I think is the more appropriate one because it's a 50-foot replanting option, certain trees that should be included in that plan in place of others. But without getting into those details, I would point out, and I would agree with General Ernst, that the purpose of the lawsuit and the argument that's being made by Mr. Lapp is that here we are trying to seize this piece of property. That's not the case, and it's absolutely right. Mr. Ernst has made this very clear. There is a strip of land that is between Lacombe Harbor Road and the tree line of the Ray property, which we allege we've been maintaining for over 30 years. And we want to keep that ownership because, quite frankly, Ms. Ray is seeking now to put a driveway to connect to Lacombe Harbor Road instead of the entranceway that she has in the rear of the property, which is supposed to be the front of the property on Oak Drive. In any event, Mr. Lapp's statements that I'm not cooperating with him is not true. We had a very frank conversation, and it was made clear. I did make clear to him that the driveway was a primary importance to my client, but he also made clear to me that it was doubtful that we would be able to resolve anything. And if he made one call to me, is that truly, 2 days before Christmas, is that truly an effort to try to resolve something on his part? In any event, we would, again, re-urge our point that this has been a very purposeful, intentional violation of zoning ordinances. And your board, if they grant a variance, in part, the variance also removes the enforcement of the fine. Your board, I think, has within their power to grant a partial variance for that little area where the house has been built in the 35 feet of no buffer zone without waiving the fine enforcement. And we're suggesting to you that if you do grant a partial variance, you should strongly consider a fine enforcement regardless of that granting. Thank you. Any questions, please?
Thank you. Any questions of the board for either party? Mr. Valentine?
Let me stop this. Or where to go? Mr. Lamont? Do they have a building permit to build a house in the no-cut zone?
Not to my knowledge, no. I've looked at the building permit, and I did not see anything that allowed them to actually place it in the no-cut buffer zone.
For the house that they built in the no-cut zone, there is no building permit?
Right, just a permit to build a house on the property within the perimeters of the zoning ordinances.
Okay. I have a question for the other attorney.
Okay, thank you.
How many trees in the 50-foot plan and the 15-foot plan? I ask this question with great hesitancy, but how many trees, reasonable trees, are there in the 50-foot plan, and how many trees are there in the 15-foot plan?
The number offhand, Ms. Ray, what was it in the 50? It was a difference of around 15 to 20.
Wait,
That's in the staff report. It's in the staff report.
well,
Yeah, and it's
somebody just
also
tell me.
itemized on both plans. I didn't tally them up, quite frankly, because both of them include Class A trees, and the 50-foot one adds in particular, 20 wax myrtles in the back section here.
Hold on,
The 15, the plan has 46 trees. The
69 and 46. I got it.
That's it?
I'm good.
Any other questions from the board?
Thank you.
Thank you. I'll entertain a motion at this time. Mr. Brookter?
We have kind of gone back and forth for the last 3 or 4 months with this case. And we keep coming back to the same point. Hopefully this is the last time that we will have to entertain this case before us. I'm going to make a motion for option 2. One of the things that we did, we asked staff to go back and work with Ms. Ray. So, and the staff has used option 2 for a basis. I'll make a motion that we approve the variance for option 2.
We have a motion on the floor to approve option 2 of the staff comments. Do we have a second? We have a second. Is there any discussion?
Yes, sir.
Mr. Ballantyne?
Excuse me, can you clarify which is which, option 1 and 2?
Helen, would you read option 2 from your staff comments, please? Oh, here we go. Helen. Here you go.
Excuse me. Option 2, the proposed replanting plan shows 69 trees to supplement the existing remaining trees within a 50-foot wide buffer for a distance of 840 feet, meeting the intent of the ordinance and the objectives of the regulation.
Thank you. Okay, any further discussion amongst the board? Mr. Ballantyne? Yes. Okay.
Okay, I have several comments. I've got 4 or 5 points. My first point is this case has already been denied. I am extremely concerned about the precedent, a terrible precedent we would set to even listen to a case that's already been reviewed and denied in over several months. My third point is how do we ignore the 300 or 400 signatures on petitions from the residents of Lacombe requesting us to deny this request for variance. The people, it's got to be a large percentage of the population of Lacombe. And they had petitions presented to this board to oppose this variance. We, the board, do not approve landscaping plans. That's a staff's job. They're very capable of doing approvals and review of landscaping plans, and I don't want to get involved in their work. They do a great job at it. It's ours, what we're here to review is a 50-foot cutback that was clearly on the plans. Total disregard when they did the initial, after the fact, cutting, destroying wetlands, destroying the no-cut zones, completely ignoring St. Tammany Parish ordinances. That's what this is about. They've intentionally cut inside those no-cut zones. Now they've intentionally built a house inside the no-cut zone, again, without the first permit. There is no hardship. In order for us to approve a variance request, there has to be some demonstration of hardship. In this case, There is no hardship demonstrated whatsoever. We have no reason to approve this request for variance.
Thank you.
That's it.
I have a question either for, we're in board discussions now. I have a question for either Mr. Leinert or legal or both. Would you all please address the legal opinion that was rendered on Mr. Lamont's question about, is this proper to be in front of us again?
Sure. There was a question raised at the December BOA meeting, and that came to us as a legal request for a legal opinion from the Department of Planning and Development, whether the Board of Adjustment had the authority to hear the second application by Ms. Ray. We reviewed the minutes of those meetings. I rewatched the October and the December meetings. I read all of the applications that had been submitted in both the 1907 application and the current application submitted by Ms. Ray. Without going into too much of the legal analysis, it was our conclusion that these were, in fact, two separate, distinct requests for relief from two different decisions or from two different ordinance or codal requirements. The first application that was heard at the October 6, 2020 BOA meeting was requesting a after-the-fact variance for clear cutting on both the north and south side buffers with no replanting envisioned. And that variance was denied by this board. And the 30-day appeal period for that decision passed on November 6, 2020. At that October meeting, this board directed Ms. Ray to go back to the Department of Planning and Development to submit a replanting plan. Apparently she had done that and sat down with the staff from the Department of Planning and Development and presented a replanting plan. That replanting plan was deemed inadequate by the staff at the Planning and Development Department. Ms. Ray then appealed that decision of the inadequacy of the replanting plan in her second application, in which case she's only asking for a variance of the replanting on the south side of the property line, no longer requesting clear cutting on the north side of the property line. And it was an appeal of the staff's finding of inadequacy of the plan that had been presented. So we believe that these are different requests for relief from different codal requirements or department decisions, which is allowed under Section 130-32 of the Code of Ordinance, subsection A7, and believe that this Board of Adjustment does have authority to hear the second application submitted by Ms. Ray.
Thank you. Is there any further discussion? Okay, let's move to a vote on the motion on the floor by Mr. Brookter, seconded by Ms. Thomas, to approve option 2 of the staff comments. As stated, the proposed replanting plan shows 69 trees to supplement the existing remaining trees within a 50-foot wide buffer for the distance of 840 feet, meeting the intent of the ordinance and the objective of the regulation. Please vote using your screens.
Four yeas and 1 nay. Motion pass.
Thank you. Moving on to BOA case number 2020-2159. Request by applicant in an HC1 highway commercial district to remove all existing pine trees within the front buffer and replace with Class B trees and shrubs. The property is located at 3701 Highway 59, Mandeville, Louisiana. The applicant is Frank Mueller. Staff comments, please.
The objective of the request is to allow for the removal of 30 existing pine trees located within the front buffer and replaced with 30 holly bushes, 4 red buds, and 10 camellias. Staff sees no compelling reason to grant approval of the request, considering that no hardship has been demonstrated. The existing pine trees are alive and in healthy condition, not showing any sign of disease or being in decline. Moreover, the request is contrary to the objective of the preservation of existing trees of the St. Tammany Parish Landscape and Tree Preservation Regulation, and it appears to be a matter of personal preferences.
Sir, are you the applicant?
Yes,
Please state your name and address for the record.
Frank Mueller. I live at 220 Doucet Road in Lafayette.
Thank you. Do you have anything further to add?
Yes, a little bit, not as much as they had, but a little bit. My landscaper couldn't be here today. Derek Dupuy, he landscaped. I bought another shopping center in Slidell, and he landscaped it, and the tenants, their business went up 30–40% after the landscaping was done. We removed over, I think it was 60-something trees off of a 2-acre piece, and the shopping center became visible to the public. And one of them said, you know, my friend said, I didn't even know this is where there was a shopping center here. And when this shopping center, David Weber, it came up for sale about 11 months ago, I said, well, there's so much I can do here if the shopping center was visible. It's right here on Highway 59. And there are 30, I counted them again a little while ago, there are 38 60-foot pine trees in front of this shopping center. And the tenants have been asking me since day one if I could try to do what I'm doing today, try to get a variance to remove the trees and replant with swamp maples, they got gorgeous leaves, and holly hedges and bushes. And I talked to Derek for quite a while. We drew up some plans for, what it could look like and really be appealing from the road. I come here once a month and walk through these centers and talk to the tenants. And I always miss this one and have to turn around and come back. I know where it is. Someone that was given an address, they're not going to find it. I mean, it would take them 3 or 4 times to know where to turn. Even though there's an entrance and an exit, it's a very busy highway, and if you take your eyes off the road, it's not like you can see it approaching it from either direction. You can't see where you need to turn, and it's a hazard in my opinion, because that traffic is flying on 59. And there's just so much that could be done with that shopping center, and I know my tenants would do so much better with their sales and so forth, and they doing well helps me, it helps St. Tammany Parish, it helps everybody. And the trees can be replaced. They can be of use to people. I would let them be turned into lumber and replant. It's not like you would be losing anything. You would be gaining a nice look, something pretty. And y'all are all after beautification for the city. And I know that, which is the reason I picked St. Tammany Parish to buy these shopping centers. It's a gorgeous parish. It's a beautiful place to live, and I enjoy coming over here. I always spend a day or two. But I'm here speaking for 5 people that are struggling. Everybody's struggling with the COVID and everything else. And in addition, finding their place of business. I don't even have a sign out front because you wouldn't see it in the trees. So I plan to build a monument, a nice monument sign, allowable monument sign, and landscape the front to where it looks like a place you would want to stop. That's it. That's all I have.
Thank you. Is there anyone here to speak in favor or in opposition? I do not have any cards. Would ask for cards before we started. Seeing no one, does the board have any questions for the applicant? Mr. Ballantyne, I'm sorry.
What is the, in St. Tammany Parish, Slidell, you're a, can I call it a strip mall? Or
Yes,
is that
that's what
bad?
it is.
You're a strip mall lord, in Slidell and in, right here on 59. What is the occupancy rate of strip malls in St. Tammany Parish?
I had 2 empty in Slidell, and they were rented within 30 days after
2 out of how many?
we did it. Over here, there's 6 suites, and 5 are rented. That 6th one I've had with a real estate company since I bought the building.
Okay, in Slidell, two were empty out of
2
how
were
many?
empty out of, I think there's 11 suites, and 9 were rented.
So it's about 80%.
And over here, and they were rented immediately, once you could see the shopping center, and, you know, we removed, like I say, we removed over 60 trees off of this 2-acre piece. It was unbelievable. Over here, we've got 38 60-foot pine trees in the front of this center. And, you know, there's 1 empty suite, and it's had a for rent sign in front of it now for 10 months. And, you know, a couple people have looked, but nothing really. There's no eye appeal from the road. And if you don't know where it is, you can't find it. You would never see it. And I would like to change that, and I know they would like to see it changed.
And you come all the way over here once a month from Lafayette?
Yes, sir. I walk through all my tenants and ask them
Once
what
a
I
month?
can do for them.
I mean, you come once a month?
Yes, sir.
Never mind.
Okay.
And I might move here. I
Come
like
on.
it. I like to fish. I
We'd
like
like
the
to
lake.
have you.
I like everything about it. I like Fontainebleau State Park. I like everything. Y'all have a really, really unique parish.
Ms. Thomas?
What type of businesses are here that, and if you've got 5 out of 6 that are active, and then obviously somebody is frequenting there. So what types
Every
of
tenant has
businesses?
been there for 20 years
Okay.
or so. The dentist, Glenn Corcoran, and the chiropractor, Mr. Schultz, and Mary Williamson sells school supplies, and
Okay, I know where you're talking about now.
yes,
Yeah,
yes.
okay.
I liked the center. I liked everything about it except those gigantic pine trees that are in the front of it. But everything else I really liked.
Thank you.
Thank you for listening.
Any other questions from the board? Nope. The chair will entertain a motion. Mr. Brookter, you have a comment?
No.
Okay, I didn't see your name. Seeing no motion from the board, your variance is not approved.
Thank you.
Thank you. Yes, Mr. Ballantyne?
Are we on the 4th and 5th cases now?
We are on the 3rd case now.
Oh, I'm sorry. I'll shut up. Oh,
So,
I have something to say before.
that's it? Okay. All right. Case number 3, BOA case 2020-2160, is a request by applicant in an E4 estate district to allow for the construction of an accessory structure within the side front yard and to increase the maximum allowable combined length of an accessory structure from 50 to 60 feet. The property is located at 16343 Bricker Road, Covington. The applicant is Ann Foy. Staff comments, please.
The objective of the request is to allow for the construction of a 50 by 60 or 3,000 square foot accessory building within the side or the front yard. And the proposed structure exceeds the maximum allowable length by 10 feet on one side. Staff is not opposed to the request, considering that the placement of the accessory building within the side, the front yard, will allow for the preservation of some of the largest existing trees on the property. The proposed location will also allow the site to meet the critical drainage requirements and avoid any impact to the existing drainage pattern. And the building will be located on an 11.51 acre parcel of land, and it will not exceed the maximum allowable size of 7.5% of the area.
Thank you. Is the applicant present? Please state your name and address for the record, please.
My name is Ann Foy. Can you hear me okay?
Yes, ma'am.
My address is 16343 Bricker Road, Covington, Louisiana, 70433. The staff stated much of my my argument, so I think this is fairly straightforward, and I'm not aware of any opposition to our request. I submitted letters from both adjacent neighbors. They understand the situation. Our plan is to build what we call a barn, accessory building. It would be a metal building. And initially, all these concerns arose during the permit process. The first concern was to place the building on the side of what was supposed to be in the rear of the property of the existing home. But due to the landscape of our property, it drops off as it goes back to the Little Chafuncta River, so the terrain just doesn't allow for building behind the house. I actually received one email that rejected us for building on the side of the house. It's really slightly toward the front, more to the side. And then a subsequent email that said we could build in that location. So today I'm really asking to clarify that. If I felt like they were saying they understood our situation, but I don't like having two conflicting emails. So if we could just document that it is okay to build it in the location we're requesting. The second issue is the size. And initially when I reviewed, I'm just a homeowner, not a builder, so I wasn't as familiar with the requirements. And I didn't pay as much attention to that as I probably should have when we drew up the plans. We're well within the percentage of our property as far as an accessory building. But the length that we chose at 60 feet was 10 feet too long. So if we would request a variance for the additional 10 feet. And the setbacks are way in excess of what would be required. We're in excess of 200 feet from the front of the property, and we tried to measure it out at, I think it was over 100 feet from the side. And plenty of tree cover so that our neighbors hopefully will not even see it. Anyway, I hope that's the information that you need. We really appreciate your time in addressing these issues so that it's clear in the record.
Thank you. I don't see any cards from anyone here to speak in favor or oppose. So without seeing any, does the board have any questions for the applicant? Mr. Valentine?
Yeah, Mr. Chairman, I make a motion to approve the variance as requested.
We have a motion to approve the variance as requested. Do we have a second? Ms. Thomas, second? Oh, Mr. Brookter, you second. Mr. Brookter, second? Third. Any discussion amongst the board? Seeing none, would everyone vote with their screens, please?
All in favor, motion passed.
Thank you.
Thank you, appreciate your time.
Now, Mr. Chairman,
Yes.
before we go, I'd like to combine the fourth and fifth cases and do those all at once.
I would defer to legal to see if there is any reason from their perspective that we need to keep these separated. They seem to be affecting the same property.
It's the same request.
I think that's fine. I think you just need to clarify whether you're going to keep the time limits the same or whether you're going to double the time for each case.
No, we're not going to double time.
So
Just
just
keep it
10,
the same.
10 minutes for each side and 5 for rebuttal?
Yeah.
Okay.
Okay, we have, but you want to make that in the form of a motion to the board? And we'll have
I make a motion to the board that we combine the fourth and fifth cases today. They're the same thing, and we could do it all at once.
Thank you.
Expedient.
Do we have a second? Second, Mr. Brookter. All those in favor?
Aye. Oh, we got to vote.
We're going to vote with our screens, okay.
Mr. Chairman, for the record,
Yes.
not state case 2020-2167, and just for the record,
You want me to state that in the motion?
I think it should be.
My comment.
Okay.
Should it not be? Just
I
for
thought-
clarity?
I thought that Mr. Valentine had stated that.
Just combine the two cases, but we.
But I think we
probably
need to clarify the case numbers.
Okay, we want to, okay. So we will be combining BOA case number 2020-2166 and BOA case number 2020-2167.
But, yeah, you
Okay,
need to-
but we will vote on those separately. Correct?
Yes.
Okay, we had a second on that motion, and I think we voted. Is everybody clear? Okay. All the votes in?
Motion passed.
Motion passed. Okay, so we're going to bring both of those cases forward together, but we'll vote separately. So I'll just read both of these separately, but I'll go through both of them. Request by applicant in an A-2 suburban district to waive the required side yard 50-foot no-cut buffer to allow for the placement of a driveway. That's 2166. 2167 states exact same thing. A request by applicant in an A2 suburban district to waive the required side yard 50-foot no-cut buffer to allow for the placement of a driveway. The property is located on the south side of Golden Lane, being Lot 4A1 Hickory Farm Sites, Pearl River. The applicant and representative, Kristen and Shelby Ruiz. Staff comments, please.
So in both cases, the objective is to allow for the placement of the driveway along the property line. And they both have also the objective of preserving, most of the existing trees on the site. Also, to reduce the number of curb cuts along Golden Lane, and also to minimize the impact on, both parcels of land, mostly on the one where you see where there's a waterway. The owner is definitely trying to place the driveway as close as possible to the western property line to try to avoid being inside that 50-foot buffer. So the two requests here will allow, as I said, to minimize the number of curb cuts, but at the same time to both have their own driveway to access their residence on their property, and staff is not opposed to both requests.
Thank you. Is the representative present? Please state your name and address for the record, please.
My name is Christian Ruiz of Slaughter, Louisiana. I'm just asking that we share this instead of, we're okay with the buffer zone to the to his property on the right. I'm okay with, mine doesn't really have trees, but if we can clear that, to just have one driveway that borders both properties in keeping his buffer zone to the right, correct? To the west side, to just keep as far away from the creek to the left of the property as possible, but to just share one driveway instead of having two driveways. and then where the property splits, to just grant them easement, I guess have like a little buffer in that 50-foot buffer zone so they can get back there too. That's all that we ask.
Okay.
Mr. Chairman?
Yes.
So if you take a look at what I included into the staff report, it's basically what's gonna happen, what your request is that you'll have, there's a requirement in St. Tammany Parish that you have your own driveway to access your house. And basically is that you'll have your own driveway on a property line, and it will allow you to fork whenever you need it to reach out to your property.
So I guess I'm just a little confused. So the property, the one driveway, it'll be one until we fork away to go to each other's property?
Yes, but your driveway
Okay.
will be on a property line itself.
Yes, okay. Yes, ma'am, that's it. And then just when we reach the property angle, we just fork to our own separate driveways, correct? Okay.
That's correct.
That's what you said. So it'll be one driveway, and then when we get to the property, it forks here, it forks them on. Yes, ma'am.
So maybe I'm assuming you're the property owner of the adjacent property?
Yes.
Mr. Chairman, would you like him to identify himself?
Yes, would you like to add anything to the conversation? Please state your name and address.
Chris Darby, from Sato, Louisiana.
What's your address, I'm sorry?
660 Fairfield Loop.
Thank you.
And I own 482, and I don't have anything to say.
Okay. Thank you. Is there anyone else here to speak in favor or opposition? I didn't have any cards, just checking. No one? Okay. Does the board have any questions of the applicant? Nope. Okay.
Two votes on each case.
Yes. Okay. Oh, Mr. Valentine?
Mr. Chairman, I make a motion to approve the variance request for 2166 and 2167. Recognize what the vote for each.
Just a question for legal. Can we state it that way, or we need to have a separate vote on each case?
It would be better just to have a motion and a second on one case. Let's take a vote,
Okay.
and then we'll make a motion and a second on the
Mr.
second.
Chairman, I make a motion to approve the variance for 2166 as requested.
Do we have a second? Second, Ms. Thomas. Any further discussion? Seeing none, let's vote using our screens on 2166.
Motion carries.
Okay, do we have a motion on 2167?
Mr. Chairman, I make a motion to approve the variance as requested for BOA case 2167.
Do we have a second? Mr. Brookter, second. Any further discussion? Seeing none, let's vote using our screens.
All in favor, motion passed.
Motion passes. Thank you.
Thank you all so much.
All right, moving along, do we have any old business?
No old business.
Seeing no old business, do we have any new business? Oh. Go back to old business or new business?
Old business. Are we all good on the cybersecurity and sexual harassment and ethics and all that, Ms. Lambert?
Mostly, yes.
Good. Thank you.
Thank you. Any new business?
3 new cases for the month of February.
Okay, seeing no additional new business, I'll entertain a motion to adjourn.
Motion to adjourn.
All those in favor? Aye. Thank you.